yours.
Okay, we're gonna get started. Sorry there's some delay with the pizza, so when that comes, we'll have it set up to the side, so go ahead and grab some. Sorry about that.
Right, and get up and grab some even if I'm talking. I will not judge you for being hungry.
So we're really excited to have Ms. Paltrow back again. She was a lot of our favorite speakers last year, so we're really excited to have her back. A few things before I introduce her. I want to thank LSRJ, FLF, and ACS for co-sponsoring this and for all their help, and also Professor Johnson for helping us set this up. And I also want to introduce Kate Jack. She's co-counsel on the Bebe Shaui case and also a Mauer grad. So please introduce yourself to her, and thanks for being here today with us. And we have a lot of information up here about Bebe Shaui and the rally next weekend on Saturday, April 6th. We're going to be passing around an info sheet and also a carpool sign up. So you can sign up, we'll give you all the information, all you have to do is show up and someone else can drive. So please sign up, and if the list doesn't come by you, sign up down here or come find one of us and we'll make sure you get a list.
There's a slight incentive that you get an awesome Bebe Shaui Rally button if you sign up, so sign up today.
And if you want an LSRJ t-shirt, Maggie, will you show us one please?
Oh yes.
They're $10 and they're really cute. So,
Wow, it's beautiful.
get a t-shirt. All right. So to introduce Ms. Paltrow, she's the executive director and founder of the National Advocates for Pregnant Women. She is a graduate of Cornell University and New York University School of Law. She served as a senior staff attorney at the ACLU's Reproductive Freedom Project, as director of special litigations at the Center for Reproductive Law and Policy, and as vice president for public affairs for Planned Parenthood of New York City. Ms. Paltrow conceived of and filed the first affirmative action federal civil rights challenge to a hospital policy of searching pregnant women for evidence of drug use and turning that information over to the police. In the case of Ferguson v. City of Charleston, the United States Supreme Court agreed that such a policy violates the Fourth Amendment's protection against unreasonable searches and seizures. She is also a Gemini and a mother of twins.
That's me. Thank you so much, LSRJ and the other organizations that sponsored this. I like this campus so much and really appreciate it. I'm honored to be here with Kate Jack, who also served as a staff attorney at the National Advocates for Pregnant Women. We have a volunteer lawyer right now who's a graduate of this law school. She's in New York. She's saving our lives every day, and her mom is here, which is just wonderful. And could you two introduce yourselves, backline, and just mention your organization?
Sure. I'm Georgianne Catalona. I run Bloomington Area Birth Services.
And which means?
Which means that we are a nonprofit organization helping moms and families from birth through pregnancy. I see some familiar faces in the audience. That's nice. Yeah. So we support women making the right choices for themselves. We consider women to be experts on their own families and their own needs. And we don't endorse any particular agenda, but just let them know all their options and support them as they make their decisions.
And the legislation you're supporting right now is?
House Bill 1135, you all should know this. We have been working for 20 years to try to license non-nurse midwives, certified professional midwives in the state of Indiana. We're the closest we've ever been before. It's passed the House. It's went before the Senate Health Committee. The vote is next Wednesday, we think. They separated the testimony and the vote. If it passes the Senate Health Committee, it'll almost surely pass the Senate and go into law this year. We've never gotten this far before. We've passed the House twice, but never made it to the Senate. And our biggest opponent is the person who's actually sponsoring the bill, which carries interesting, complicated political stuff. So if you ever want to know that story, just let me know. Thank you.
I'm Shaui, I'm the program director with Backline, and very excited to be here. I'm a native Hoosier, but I have not lived here for a very long time. I'm coming here from Portland, where Backline has, for the most part, been based, but now we're moving to Indiana and trying to take over the world a little bit at a time. But Backline is the only talk in the country that offers support before, during, and after a pregnancy experience, regardless of what choices people make. So we are judgment-free, unbiased support across the spectrum of pregnancy experiences, and we're looking for volunteers as we build our base here in Bloomington.
That's great. So I decided not to use slides. I hope it works. I got my start in my law career defending the right to choose abortion, and I've worked at many of the mainstream pro-choice groups. Forgive me, I'm getting over a cold. So. One of the places I worked as a Georgetown Women's Law Fellow was at the National Abortion Rights Action League, and they had been doing a campaign in which they asked people to write letters about why they or somebody knew they had an abortion, and this was in the mid-1980s, so it was not that far away from when Roe v. Wade was decided. And I had the privilege of reading hundreds of letters from people describing why they had an abortion, or somebody they knew did. And what was really educational to me, and has shaped a lot of my career, is that not a single one of those letters, not one of those letters did a woman write, I had an abortion because I have a right to choose, or I had an abortion because it's my body, my right. They were all talking about the constitutional principles and moral values of responsibility and personal liberty in its most profound sense. Women wrote about how they already had 2 kids, one of whom was severely disabled, and if she had another child, she would not be able to provide the care her disabled child needed. About a husband going to serve in Vietnam and a sick in-law she needed to take care of. It was about responsibility to self and future children, their unborn children. I want to have a family, but I want to do it with a person I love, and it was 1980s, a man I love, and I want to be able to support my family. I want to complete my education so that I can be a responsible citizen and a good parent. And all of the letters were about the kind of liberty that was recognized in the Supreme Court case of Meyer v. Nebraska. Liberty means the right to family, education, religion, carrying out your religious beliefs, which women wrote about as well. And so it wasn't the language of choice or my body, my right. It was a language of values and responsibility and connection. I found that realization that much of the mainstream pro-choice movement, the talk that they've encouraged us to use isn't really reflective even of the women that they are advocating on behalf of. And that was part of the reason I found my way to the reproductive justice movement, and many of the founders like Loretta Ross, who defined reproductive justice as more than just a choice, which can mean a lot if you are a white, privileged, middle-class, second-wave feminist. You can have an abortion, and wow, all the doors are open to you. You can finish your education. You can marry the man you love. You can have children and raise them the way you want to without the history and humiliation of forced pregnancy. But if you're discriminated against on the basis of ability or race, you can get an abortion and you still can't necessarily have the children you want and ensure that they're going to have the education they need. And so their definition, their vision is much bigger than pro-choice. Their vision is reproductive justice that includes the economic, social, and community circumstances that enable people to make the choices they need to make about their reproductive and family lives. I started out defending the right to choose abortion, and then started getting the cases where women who didn't want to end their pregnancy were being hurt by anti-abortion arguments. And one of those cases has really defines so much of what I've learned, and I go back and I revisit it often. And that's the Angela Carter case. Have any of you done that in any of your classes? At a young age, around 13, Angela Carter was diagnosed with a rare form of bone cancer and told she was going to die. But she and her parents fought that definition. They found their way to specialists at the National Institutes of Health, and through multiple chemotherapies and surgeries, including removal of her entire leg and half her pelvis, she survived into adulthood. When she got married, and she got pregnant and very much wanted to be pregnant. She had a hard time getting OBGYN care, which disabled women often find a challenge. So if you're looking for justice causes to work on, that's one of them. How do you get a one-legged woman onto your stirrups? Prejudice, why should somebody like that even be having children? But she found her way to the George Washington University Hospital's high-risk pregnancy program. And shortly thereafter started to say, I think something's wrong again. And they kind of said, you don't have half your pelvis, of course you don't feel great. When they finally listened to her, they found a tumor the size of a football in her lungs. And unlike other cases like this, there was no fight between Angela and her doctors. Angela, her parents, her husband, her attending physicians all agreed the thing to do was to try to find a way to keep her alive for as long as possible. She was willing to undergo radiation, chemotherapy, anything. But a hospital neonatologist overheard them talking about what should we do if she dies. Should we do an emergency C-section and try to save the baby? She was 27 years old and 25 weeks pregnant. The neonatologist did not bother to talk to Angela or even her attending physician. She ran to the hospital lawyer and said, I can save all 25-week fetuses. This fetus has a right to life. We should cut her open now and save it while we can. And the lawyer, instead of saying, wait a minute, that's not the law in the United States of America. In fact, to the extent there is law on this issue, one of the most iconic cases is McFall v. Shimp. These cases are very rare because, most people don't even think you could do this. A guy named McFall was suffering also from a rare form of cancer. His only chance of survival was a bone marrow transplant from somebody with a matching bone marrow. A cousin agreed, tested, was compatible, and then at the last minute said, no, I won't do it. And the cousin took him to court and tried to get a judge to order the cousin to go through with the bone marrow transplant. And this was in the 1970s. And the judge said, I think your cousin is being immoral. I think you should go through with it. But we live in the United States of America, not the Soviet Russia, not Nazi Germany. Judges in the United States of America are not empowered to make decisions about weighing the value of two people's lives. Your life is so important, I can take custody of you and give you a kidney. Your life is more important than yours, I can get you to do a blood transfusion. We don't do that. We do ask people to make sacrifices for the public health in general, so we require inoculations, we require certain service of our citizens to a general good, but we do not empower individual judges or anybody else to decide, even if it's a parent, even if it's an identical twin, that they can take custody of you for the benefit of somebody else. The lawyer didn't seem to know that, called an emergency hearing at the hospital to determine what the rights of the fetus were. A lawyer was appointed for Angela. He knew a lot about patient rights, but nothing about reproductive rights. They appointed a lawyer for the fetus as if it were already separate from Angela Carter, who actually knew enough about reproductive rights to talk a very good game. And another lawyer showed up here from the District of Columbia on behalf of the fetus, even though, in fact, he did not have authority to do so. And in the course of an afternoon, the argument was this neonatologist could save the baby, the fetus has a right to life. It was understood. Angela at that point was in the intensive care unit. She was in and out of consciousness. The judge who in other cases, historical cases that he had been called in on where somebody was refusing a transplant, for example, even though they had everything ready and they wanted to make sure the person was making a decision, never went to her bedside, never bothered to talk to Angela. It was understood by everybody that forcing her to undergo the surgery could kill her, that moving her from the ICU down to the surgical ward, cutting her open, subjecting her to the surgery could kill her. And yet, at the end of that afternoon, the judge ordered the surgery. And there was an emergency appeal to 3 judges of the highest court of the District of Columbia. It was before cell phones, before even conference phones. They're fighting over a telephone. And the 3-judge panel upholds the court order. None of her attending physicians even want to do it, but the hospital finds somebody. As she's being taken away from the support in the ICU unit, her doctors explain it's a court that's decided you should have the surgery and it could kill you. And she's saying, I don't want it done, I don't want it done. She's intubated, so she's mouthing it. They take her down, they perform the surgery. The fetus is born alive, but dies within 2 hours. And Angela Carter dies 2 days later with the cesarean surgery listed as a contributing factor. The court that upheld, the 3 judges who upheld this decision that afternoon subsequently wrote out their opinion, including a sentence that said, we were right to order the surgery, but condolences to the family for the loss of Angela and her baby. I'm happy to report that we then sought en banc review by the highest court of the District of Columbia, and had many amicus briefs from a range of organizations, including the AMA and ACOG and Concern for Dying, all kinds of organizations. And the court reversed the decision and said, just because you're pregnant, you do not lose your right to medical decision-making. Even if you are unconscious, then we use substituted judgment, which isn't what it sounds like. What it means is you find somebody who would know what you would have wanted and articulate for the person who's unconscious what they would have wanted. And they said, although there might be some circumstance where a court could order this kind of intervention, we can't imagine what it would be. It can't be for cesarean surgery. It can't be because the woman is in her third trimester. It can't be because she's unconscious. It can't be because the fetus was viable. And they, in their opinion, they treated this as a viable fetus. So really, under no circumstance could they imagine ordering this to happen. There were two dissenters, as I recall. One of them had been one of the judges who originally ordered the surgery, Judge Belson. And I appreciate him so much. And the reason is, he's done something that no judge anywhere has done. Many judges in a wide variety of cases have argued that fertilized eggs, embryos, and fetuses should be viewed as completely legally separate from the pregnant woman. And he argued that. He was focused then on viable fetuses. Now judges go all the way back to fertilization. And he argued that viable fetuses were really persons, and he pulled law from here, there, and everywhere to say why he thought that was true. And because they're persons, he said, it's always right to balance the rights of the pregnant woman against the fetus. They're both persons. But he got what the implications of that balancing would mean. And so he said, what Angela Carter suffered and experienced was okay because the expectant mother, by undertaking to bear another human being and carrying an unborn child, places, quote, herself in a special class of persons. And he also talked about how pregnant women are a unique category of persons. When else in U.S. history have there been a special class of persons?
Japanese Americans around World War II.
Right, internment, that justified internment of them. Who else? What other special classes of persons have we had? Slavery, absolutely.
Mentally handicapped?
Yes, mentally handicapped, and also think of Jim Crow. You know, you don't get the right to vote, you don't get all of these things. So what he articulated for us is what really is at stake in this debate that we often think is just about abortion. It is really about whether we will have a set of separate and unequal law for women who are pregnant and really for women who are fertile and could be pregnant. I gave this lecture at the University of Maryland a long time ago, and I had compared, I told them the story of McFall v. Schimpf, my cousins. We were talking about the Angela Carter case, and a number of the students were really persistent in arguing that the forced surgery was appropriate. And I finally posed back to them, I said, okay, explain to me, please, how it is that if you can't, court doesn't have the power to force one person to undergo surgery for the benefit of another. How is it that pregnant women can be forced to have surgery for fetuses that have not even been recognized as persons, who are not under the law? And you know what he said? He said, that's just the burden women bear. And don't, yes, but that is, we all think women have come so far in the struggle for equality. But the struggles for equality in this country are in their infancy. We did end slavery, but then we had Jim Crow, and now we have the new Jim Crow, Michelle Alexander. We did win the right to vote, but the idea of women's equality, women of any color's equality, is barely a blink in the eye of human history. So if you think we have achieved it all, or we're done with that, you're sadly mistaken. So let's use the Angela Carter case for a minute to sort of talk about this. If you think about the facts of that case, what rights was Angela deprived of? In constitutional terms. Just start listening to them. Go ahead.
Her life.
Well, thank you. Usually that is the last one. She said her right to life. I mean, what I see, and I did this talk in Fort Wayne last night. They weren't law students, okay. But when people see a pregnant woman, when judges are deciding a case, and when even lawyers on behalf of women are arguing the case, the tendency is to see only the reproductive rights question. It's as if everything else disappears. So the Angela Carter case is one about the right to life. What else?
She lost the right to lose her life for her child. She was going to carry on as long as she had to for the baby to live. So she lost the right to give her child life.
So it's a reproductive rights, that is a violation of her reproductive rights, absolutely. Other rights?
Medical decision.
Yes, medical decision-making, what else? Bodily integrity. She also lost a really big one, and the court in her case did also recognize this: due process. If you are convicted of murder and sentenced to death, you typically get 12.5 years of due process before they can actually put you to death. She got an afternoon. And what was really interesting to me is there were only two groups that defended what happened to Angela Carter, and one of them was the United Catholic Conference, now known as the United Catholic Conference of Bishops. And they filed an amicus brief in which they argued that what had happened to Angela Carter was right, that this fetus should be viewed as a separate human being and with personhood rights, and that she was going to die anyway, that she had no rights to defend. And interestingly enough, they said, they wrote the brief as if nobody knew what she wanted. And they said, but even if we knew what she wanted, and it was to refuse the cesarean surgery, that would be tantamount to having a third trimester abortion, and she had no right to that. And I reread their brief a few years ago, shortly after I happened to be in D.C., when there was a congressional hearing on the Terri Schiavo case. How many of you know the Terri Schiavo case? Many of you. Terri Schiavo was a woman who fell into a coma. She had been in a completely vegetative state for many, many years. And in accordance with her clearly expressed wishes, as court after court after court found, her husband wanted to take out the feeding tube. Her parents, with a lot of support from the United Catholic Conference, the bishops at that point, were absolutely vigorously involved in saying that she should be kept alive. And in those arguments, the Catholic Church said, the pro-life position is that you value every form of life, no matter how disabled it is. And they described Terri Schiavo as just like mentally disabled. And her life had value even in a completely vegetative state. Okay, so do me a favor, get the pizza and keep listening. That every form of life has value, and the light bulb went off. I thought, how is it that they can support Terri Schiavo, who had completely no brain function whatsoever, and say this life is valuable? And Angela Carter, who was actually communicating, was alive, had an interest in preserving her own life, they argued what had happened to her was right. And not only so correct, they argued the court should hear the case because other cases like these would happen, and there should be a clear precedent that deciding the right to life of a pregnant woman in the course of an afternoon was plenty of due process. And the light bulb was, oh my goodness, pro-life, the word life in the singular, is literal when it comes to pregnant women. There's only one life that the movement cares about, and that's the life of the fertilized egg, embryo, or fetus. And what I've come to understand, too, is that many people, as opposed to political movements, that identify as pro-life, and this is true for many pro-choice people as well, is that they do value fertilized eggs, embryos, and fetuses. They do want to see an end to abortion, but they also value the life of the pregnant woman. They don't want to see Angela Carter forced to have cesarean surgery and killed. They don't even want to see women who have abortions locked up. I don't know how many of you know this, but 61% of women who have abortions are already mothers. So this idea that there are two kinds of women who have abortions and kill their babies, and the good women who have babies, they're all the same women. They're just at different moments in their lives. And so this notion that we can have a society that shames and blames women for certain decisions and not have it affect how we view all women is kind of absurd. But I think the majority of people in this country are really pro-lives. That regardless of their view on abortion, regardless of how they value unborn life, they also value the lives of mothers who have children, who will have children, who are connected to their families. But if you look at what happened in the Angela Carter case, you'll notice that she wasn't just deprived of her reproductive right, although that was significant. She was deprived of every single right. And what this case and others, I specialized, end up specializing, specializing in these cases where anti-abortion arguments are used to hurt women who have no intention of ending their pregnancies. And every one of these cases people react to is like that weird case that happens to other people. We've had cases, many of them at one point were brought against the least popular women, not popular to anybody, pro-choice, pro-life, anybody, African-American women who gave birth to children who were overwhelmingly born alive and healthy but tested positive for any illegal drug. I didn't bring with me, but I can get to you. Just to let you know, it turns out that despite what you've heard in every newspaper report you've seen, and every time there's a new drug, illegal drugs are not safe to use during pregnancy, but they are not uniquely inevitably harmful. In fact, the risks of harm from prenatal exposure to methamphetamine, cocaine, heroin, and marijuana are about the same, and in some cases less than exposure to cigarettes. And I always like to point out that I am a nicotine baby. My mother smoked through the whole pregnancy. She would say, I didn't know any better then. And I would say, and if she hadn't smoked, there's a good chance maybe I would have been a for-profit lawyer. Maybe a taller too. I don't know. And many other kinds of cases that I'll tell you about. So what we finally decided to do is a study, a true research study, and we started gathering documentation of cases in which pregnancy, being pregnant, was a necessary element of a decision to arrest, detain, or forcibly intervene upon a pregnant woman. And we looked between 1973 and 2005, when Roe was decided, and a time period where we can have an end and know what the cases were. It has now been published in a peer-reviewed journal, the Journal of Health, Politics, Policy, Law. And we were able to document over 413 cases. The truth is we know that that is a vast undercount. These are cases in which women were arrested, detained in jails, in mental hospitals, in regular hospitals, women forced to have, or attempts to force them to have blood transfusions, cesarean surgery, closing up their cervix. All women who are arrested for, well, I'll come back to that. So we found all these cases, but we know that they're a rigorous undercount. We know that as probably when you read statistics on rape, they explain that it's likely it's an undercount because people don't report, because our reporting mechanisms aren't. Well, there's no reporting mechanism for these cases. And since there actually is no legal authority for any of these cases, there's no database to go to anywhere. Women are charged, for example, with child abuse or child endangerment if they do something during pregnancy somebody doesn't like. Well, there's no special crime of child endangerment, so if you looked at a state's records for how many people are arrested for child endangerment, you couldn't tell which of those cases involved pregnant women. Cases where the civil commitment procedures have been used, most of them we can't find because those are private. If a woman has been detained through a civil court action arguing that the fetus is a appended child, we probably aren't going to hear about them unless they found us, unless they found somebody and it became public. So there are all these cases, and we're going like, how is this happening? We've often gone in and challenged the arrests and prosecutions, and we win like we did in the Angela Carter case. We set precedent in these states, and even in the states where we've had positive decisions, somehow we keep seeing these reemerge, reemerge, reemerge. What is it? What is it they rely on? And the answer is that they rely on post-Roe anti-abortion measures and pro-life, so-called pro-life feticide measures. And for those of you who don't know, 38 states now have feticide or homicide of a viable of a fetus laws. Each and every one of those laws was passed in the wake of extreme violence against a pregnant woman. So as you probably know, how many of you have heard of the Billion Rising and Eve Ensler's work to end the worldwide epidemic of violence against women? So in the wake of sort of the most horrifying violence against women, and by the way, murder is the first or second leading cause of death, maternal death in the United States, they swoop in, the anti-choice, with a piece of legislation that says the real issue here is, oh my goodness, we can't punish as a separate crime the harm to or the loss of life of the fertilized egg, embryo, or fetus. That's the real issue here. And they get the law passed saying that our goal here is just to punish the person who's doing the violence against the pregnant woman. Now, violence against pregnant women is different than violence against somebody who's not pregnant. But the way you can acknowledge that is to enhance the penalty, and you keep the focus on the pregnant woman. So they have used violence against women to put these laws into place in 38 states. They hijacked the debate about violence against women to one about whether we can treat eggs, embryos, and fetuses as entirely separate. And then, you know what we found? That those are the laws. The anti-abortion laws that include declarations of separate rights for eggs, embryos, and fetuses, as personhood measures would do statewide, the ones that have been proposed in Colorado and Mississippi and so far defeated. They cite the anti-abortion laws, the feticide laws, as the reason why the court can interpret the word child in the child abuse statute, delivery of drugs to a minor, the word minor in that statute, to include the fertilized egg, embryo, or fetus. And in some of the cases, the women are arrested directly under the feticide law. So Melissa Rowland gave birth to twins in Utah. She falls down she gives birth to twins in Utah. One of them is stillborn. And she is arrested under the Utah feticide law. Why? Because the hospital said she refused the recommendation of cesarean surgery 2 weeks earlier, and if she had had the surgery 2 weeks earlier, they both would have been born alive. When Texas passed its feticide laws, in response to, and promised this would reduce violence against women. By the way, not a single state has studied to see if violence against women has been reduced in any of the 38 states. It was immediately used by a prosecutor in Amarillo County to send a letter to the hospital saying, if you have a patient who's using pregnant patient using an illegal drug, you must turn her into us. And it said, and that'll help us get them into treatment. Well, I searched for drug treatment for low-income pregnant women in Amarillo County. Not a single place that even said they accepted pregnant women for 100 miles. And by the way, it was totally illegal for the doctors to turn women over, and still they did it. They didn't say Ferguson versus City of Charleston says I could be sued if I do this. They turned those women over, and 40 women were arrested. And although we eventually got the courts in Texas to say, no, that's not what this law was intended for. It was intended for third parties who attack pregnant women. 40 women were arrested. Many of them spent years in jail. In one case, the named plaintiff, Tracy Ward, it's a very long story, but as her case was heading toward trial before we were able to stop it, I will just tell you this, it was one of the saddest cases I've worked on. This is a woman who clearly was born with a mental disability, clearly born in a part of Texas where no resources were ever provided to her. She had basically survived on the streets. She had had a lot of kids, and the prosecutor was going after her for that, and they were questioning family members to show that she was a bad person, and talking about her having so many babies. And the last one had been exposed prenatally to cocaine. And they said, see, she's having all these babies, and I think it was her brother or a friend and neighbor said, oh, you mean those are rape babies? That her pregnancies were the result of rapes because she was so vulnerable on the streets in the part of Texas that she was in. And the prosecutor, when you go to trial and you're going to use personal evidence against somebody around their credibility and their personality, they said that if the case went to trial, they would use as evidence against her the fact that she had refused voluntary sterilization. In any event, we found all these cases, and what we have learned from them is as follows, that there is no way to add fertilized eggs, embryos, and fetuses to the Constitution without subtracting pregnant women. That the argument for those who are supporting these personhood measures, and those personhood measures in disguise, is that we live in a country where we always add new people to the Constitution. We expand the community of constitutional person in our country of liberty. So we added slaves to the Constitution. We added women. But when they added slaves, when we had the Emancipation Proclamation and then the amendments to the Constitution, although white slave owners argued they were losing one constitutional right, the right to property, a right I hope we would disagree with them that they were losing, they didn't lose their standing as constitutional persons. They didn't lose their right to bodily integrity or the right to life or the right to medical decision-making or their reproductive rights or the right to due process of law. When women were added to the Constitution through suffrage, and they have not fully been added because we can't in America quite deal with equality doesn't necessarily mean sameness, and we have not gotten there yet. When women were added as much as they have been to the Constitution, men lost a lot of privilege, but they did not lose their personhood, their right to life, their right, by the way, the other right that Angela Carter lost, physical liberty. When you take a woman from the ICU unit downstairs and force her to have surgery, she's a prisoner. That's physical liberty. No question about original meaning and language in the statute. When suffrage happened, when women gained the right to vote, men did not lose those rights. As these cases demonstrate, there is no way to add fertilized eggs, embryos, and fetuses to the Constitution without subtracting pregnant women and creating a system of separate and unequal law that we are calling the new Jane Crow. And the question is, will Indiana be the first state to declare itself as one in which women are treated as separate and unequal persons? And that's what the Bebe Shaui case is about. For those of you who don't know about that case, Bebe Shaui is a woman in Indiana. She became pregnant with a man who was separated from his wife, who indicated he wanted to have this baby with her. She was looking forward to having this baby with him. And when she was about 33 weeks pregnant, he announced to her he wanted nothing to do with her. He was going to go back to his original wife and family. And according to news reports, he left her sobbing in a parking lot. At that point, she was so ashamed and humiliated and whatever else she was feeling, she attempted suicide by taking rat poison. Fortunately, friends found her. They got her to a hospital in time. She got some help. She regained her hope for her life, which including her pregnancy. She did everything the hospital asked her to do to continue this pregnancy and give birth to a healthy baby. She took the medications. They told them she underwent cesarean surgery. The baby was born alive, Angel, but did not survive. And she held Angel in her arms as she died, and they then didn't support her. She was reported to the police, and she was arrested on the charge of murder of a viable fetus and attempted feticide. And in the United States of America, if you're charged with murder, guess what you don't have a right to? Bail. And I point this out, I'm going to do a little aside again. The pro-life political movement reassures its base that if Roe is overturned, don't worry, it'll just be like 1973. When really they didn't go after pregnant women, they only went after the doctors. We're a movement that cares about women. We don't want to see women go to jail. Don't worry, they won't. They didn't go to jail before Roe, they won't go to jail after Roe. But let me just tell you, this is not your mother's 1973. In 1973, and by the way, there were some women arrested before Roe, but they did mostly, to the extent they did anything, they went after the docs. And then they would turn it into an attack on midwives, but that's another, When Abortion Was a Crime, a book by Leslie Reagan, if you want to read that. In 1973, in the entire country, I think there were only 300,000 people in prisons and jails. Today, there are 1.5 million people in prisons and jails, and 4.8 million people in probation parole under the control of the criminal justice system. And here's, in 1977, wait, I have that. Okay. Between 1970 and 2000, the population in the United States of America grew 40%. The population of people incarcerated and under state control grew by 500%. This is not about population growth. We have more people imprisoned in the United States of America, incarcerated, than any country in the world. More so proportionately, more so numerically, and there are now more African Americans incarcerated in the United States of America that were in slavery at the time preceding the Civil War. This is a result of the war on drugs. This is a result of other things, including we now also have. So nobody was being arrested, certainly not women. Women's growth of incarceration, there are now 200,000 women in jail. Most of them are mothers. 5% of them go in pregnant. and their rate of incarceration grew by 938%. We also have now a prison industrial complex in which private corporations build prisons and make money by keeping people in those prisons. There's now a financial corporate incentive to keep people in prisons. If you care about reproductive rights, you have to care about criminal justice. And you'll see in the United States of America, when somebody was accused of being here illegally, they weren't detained in a detention center during the pendency of their hearings. They are now detained not in private detention centers. There's a lot of evidence that this has come about as a result of lobbying by the groups that own those prisons. And one other thing has changed too. How many of you have had to be urine drug screened for a job? Please raise your hand. Could a couple of you talk about what job that was and what the experience was like? Loud.
I cleaned buses.
You cleaned
And so I had to get a drug test to clean buses. I don't really know why. Didn't really make a lot of sense.
Did they tell you why? Did they tell you what
They did
information?
not tell me
They
why.
didn't tell you anything. And when you did the urine drug screen, did you have to do it in front of somebody, or did you?
I didn't have to do it in front of somebody, but I had to go into a room with, like nothing and make sure I looked at that and make sure I didn't flush the toilet. It was strange, and then they accused me of drug use because I am on prescription drugs that show up on their tests, and they had to get verification from my doctor, and I was like, I don't really want to clean buses that badly.
Interesting.
It's not a very good job.
You and then you.
I was drug tested for a factory line worker position to protect the moral integrity of the company, was what they said it was for.
Well, they at least gave you a reason. They don't usually even do that, but.
Because it was a conservative company and they said it was for morals, and yeah, I had to get they searched my purse, they made me turn out all my pockets and make sure I couldn't wear baggy clothing. And then they give you a time limit to go to the bathroom. You can't flush or you get in trouble and have to redo it. And they had to retest one of mine because of prescription drugs.
How about you?
Mine was in the 1990s for a position as a staff attorney at a public utility in Indiana. And I gave them the urine. I wasn't happy. Oh, and then they wanted to do a gynecological exam. And I said no, but they hired me anyway.
Okay. Anybody else want to?
My high school managed to require tests for all high school students.
Okay. Go ahead. It's when I started to get politically induced
The
Tourette's.
entire high school.
That's up around something.
I had to be drug tested to work at a pet store. I don't know why. It's like, if you want the job, you have to do a drug test.
Well, I think the reason will be quite clear. I had a security clearance and worked with the Department of Energy and had confidential classified information. So you had to do a drug at the beginning. But I had surgery. I had surgery and I was on narcotics for pain of the surgery. Not a lot of narcotics, but some narcotics. And I had showed up to work. It was like the 5th day after my surgery, the first day I was back at work, and I got randomly chosen to get drug tested, and I couldn't leave. They would not let me. I went in and I was like, here's the deal, and I have a bottle, and here's my prescription, and I've taken 6 days of sick leave and surgery, and it's not the first time I've had this surgery. But I was put in a room with the armed guards because we had full Kevlar, M16, military men who guarded the facility where I worked, and I had to sit in a room because I basically admitted to being on narcotics when they were going to drug test me for about 3 hours. They're nice people, they're good people, it was just the procedure they had to go through.
Okay, so let me just, I don't have too much more time, so I just want to, did any of it occur to you that your rights were being violated? I realize these are private companies and
Yes, maybe.
yeah, okay, good. A lot of people don't even think about that. What you should know is that these policies were put into place based on the claim that companies lost money due to people who were addicted to drugs and not doing their jobs and costing companies. There have been studies that now say that's absolutely, there's no association, no connection between that level of drug use and saving corporations money. I personally think this is all absurd. We should just have a tax that takes money from us and gives it directly to the multi-billion-dollar drug testing industry. But why do all this except to humiliate you and so forth? That is part of it. Because there's nothing, by the way, even drug use doesn't tell if you're addicted. It certainly doesn't tell if you can parent or fold shirts or clean buses or anything else. And the truth is that the vast majority of people who actually are addicted, have drug problems, are fully employed. But here's the point. This is not your mother's 1973. Once they have your urine, what else can they test you for? Pregnancy. You got it. So today, if Roe is overturned and you have an abortion, what do you think is going to happen? We have a mass incarceration system that has no longer any hesitation for putting mothers in jail. And women in labor still, it's only one court in 2007 ever said that it's cruel and unusual punishment to shackle a woman while she's in labor as a prisoner. What do you think is going to happen? It is not your mother's 1973. Among the cases we found cases where women have been arrested for having an abortion. They have actually, since Roe, been prosecuted for illegal abortion or murder or manslaughter. Recently in Idaho, a woman who couldn't access an abortion in southern Idaho, Jenny McCormick, got an abortion pill online, successfully, safely ended her pregnancy through a self-abortion, which is what women do when they don't have access. Somebody found out she was arrested in Idaho. Where were the pro-life groups saying, no, that's not what we meant. We promised you. This wasn't what it's going to look like. And yet, that's exactly what it's going to look like. There's a case where a woman was arrested, a young woman, first-time offense. She was involved in some check-kiting scheme. But the sentence had to be probation, given the level of the crime. She was being held in jail until sentencing. She wrote to the judge. She said, I'm pregnant. Please let me out so I can get an abortion. And the Ohio judge said, no, I will let you out if you promise not to have an abortion. She refused, and the judge kept her in jail so long she couldn't have an abortion. If you are going to murder somebody, which is what people are now calling abortion, the state has the power to keep you from committing that murder. So the idea that even if you're wealthy, you can leave the state and go to New York or California or wherever it's still legal, they can hold you and keep you from going and having that abortion. This is not your mother's 1973. So if you care about reproductive rights and justice, you have to understand our criminal justice system and the drug war, which is what has fueled this incredible system of control. So Bebe Shaui. So Bebe Shaui is charged with murder. She's held without bail. It takes us a year to get them to recognize that she should be allowed out on bail. The good work of Kate Jack and Pence and Hensel and NAPW. And I think the first time since the 1800s that they've ever said that they had to provide bail in a murder case. But she's far from free. She's been wearing an ankle monitor that she has to pay for, $12 a day, plus the bail itself. And then here's the thing. She had, what will that decision mean in this case? If this case is allowed to go forward, and so far the courts here, as other states have stopped cases like this, so far the Indiana courts have said, no, let her go to trial for murder and attempted feticide. What happens if it's upheld? If this is allowed to go forward and she goes on trial and this is upheld, what you have is a decision not just about Bebe Shaui, not just about pregnant women who attempt suicide. Let me point out, it is not a crime to attempt suicide. So the decision will be that if you are pregnant, we have a system of separate and unequal law because you can be prosecuted for murder or attempted feticide, even for taking any step toward it. Attempted feticide as applied by, and these laws, by the way, murder of a viable fetus and feticide, were passed in the wake of violence against women. One of the cases involved a bank robber who shot a pregnant woman with twins who lost both twins. And they are now turning it around and saying it can be used to commit state violence against a pregnant woman. What is it that it's going to say? The attempted feticide applies from the moment of fertilization. And the definition of the crime is any intentional act that could lead to the death of fertilized eggs, embryos, and fetuses. Let me, just in case you haven't had criminal law yet, that's an intentional act. I intentionally picked up the bottle of water. It isn't your intent toward your pregnancy. It is an action that you take. if this law passes, not only is it separate and unequal, that it's not a crime for everybody else to be human, to experience depression, to suffer suicidal ideation, to attempt suicide, but for you, pregnant woman, you are a criminal that can go to jail for life. It means that absolutely every aspect of women's lives can be regulated, surveilled, and punished by the state of Indiana, and by people acting on its behalf. Disgruntled boyfriends, unhappy husbands, angry doctors. And if you think I'm making this stuff up, I'm going to tell you some of the cases. In Iowa, Christine Taylor was pregnant with 2 children, fell down a flight of stairs, goes to the hospital because she's worried about her baby. In the course of being examined, and thankfully she was fine, a nurse or somebody interviews her, and she admits that early in the pregnancy she had ambivalence and had considered having an abortion. They let her go home. On her way home, a police car comes up behind her, stops the cab, and arrests her on charges of attempted feticide. There was such a national outcry that they released her after 2 days, but she's got 2 little girls at home. She had just moved to Iowa. She left them with a neighbor she barely knew. She didn't know if she'd ever get out of jail. And they said, well, we let her go because she was only in her 2nd trimester. But if she'd been in her 3rd, we could have kept her there. In Tennessee, a woman was in a single car accident recently. Just herself and the car. They give her a breathalyzer test. She is not driving while intoxicated. She's not even close to the limit. And yet they arrest her. Why? Because she told them she was 4 months pregnant. And they charged her with child endangerment and charged her with driving while under the influence, even though she wasn't under the influence, because apparently for pregnant women there's a separate and unequal law called driving while not intoxicated and pregnant. Just last week, and what it does is going to do is completely distort health care for pregnant women. Because what it means is if you disagree with your doctor, if you would rather have a home birth with a midwife, if you don't want to have the cesarean section your doctor insists upon, if you don't, as in one case a woman didn't come back for a 2nd gestational diabetes test, they used civil commitment proceedings to lock her up. They said she's not mentally ill, but she has a mental health problem keeping her from effectuating necessary prenatal care. They locked her up in the hospital where they were trying to get her to get tested for gestational diabetes, and guess what happened? They never tested her for the gestational diabetes. This is, you think by forcing people, that's what's going to go, okay. So what it will do is give doctors the ability, and I know some of you have to go, I'm going to wrap it up, but stick with me for another 2 minutes. The ability to say, if you don't listen to what I say, if you don't obey me, I can have you arrested. And I am not making that up either. 2 weeks ago in Florida, a woman who had had 4 previous cesareans, was pregnant with her 5th baby, went to for an exam. She had her 2.5-year-old with her, 3 other kids she homeschools. She had the only car. And they do the ultrasound and stuff, and they're nervous. And they're like, we'd really like you to stay today and have the cesarean. And she says, I'll have it Friday when I have childcare and everything else set up. Nothing you're telling me suggests to me that this is a crisis. I'll be back Tuesday. Wednesday, she gets an email from her doctor who, in writing, says, we're very upset. We think you need this right away. If you don't come in this afternoon, I will send police to your house to come get you and force you to have a surgery. And they had done that to a woman in Florida before and held women in prison. And even though the courts have said this is not okay, this is the culture. This is what we have as a result of feticide laws and so forth. The question I want to ask you is, will I see you April 6th, next Saturday, at the City Market at 2 o'clock in a demonstration, a rally for Baby Shaui and for reproductive justice. And I want you to think very carefully about your priorities. I do know that you have exams and families, and everybody in this country and our economy is struggling. Very hard to do any political action in this country, and that's probably pretty deliberate. But Indiana is on the verge of not only putting this woman through more pain and suffering and the humiliation and the cost of a trial, but of setting a precedent for a new Jane Crow in which the state will have the authority to surveil, control, and punish not just every pregnant woman, but every fertile woman would now have the responsibility to know at all times if she is pregnant, because from the moment of pregnancy, anything she does could be viewed as and punished as attempted feticide. I don't want you to be in the position of saying, if they do this, looking back and saying, I could have been there, but I didn't go. looking back 2 years, 5 years, 10 years from now and asking yourself, I could have been there and helped stop this. I could have been there to tell Terry Curry, the prosecutor, that this is wrong and he should drop the charges and that this will set precedent. I'm a law student. I know what precedent is. And you can't just have a decision for one woman. So I really hope that you will do whatever you can to make it, to get other people to be there. If you can't go, to get somebody in your stead. There is also, right on change.org, there is a free Bebe petition. Terry Curry, the prosecutor who has pushed this, will not let it go, is noticing every time an Indiana resident signs onto it. He has hopes for higher office. You can write, if you can't go next Saturday, and this is not an excuse not to go to his office, send a letter, create another protest. The trial has now been postponed till the fall. But don't look back on your life and say, why wasn't I there to speak on behalf of Bebe Shaui, to speak on behalf of women, and to support a true culture of life, one that includes the women who give birth to that life. Thank you very much.